Thank you for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program, coming to you live from Washington, D.C. We are uncovering each part of the DFARS, or Defense Federal Acquisition Regulation Supplement, every Wednesday at 12 p.m. Eastern. As you know, the DFARS are the rulebooks for contracting with the Defense Department, and we have been moving sequentially. So we started with DFARS Part 201 in January, and we'll be finishing with Part 253 in December. Our webinars are every Wednesday and are provided complimentary. They're recorded and can be downloaded from our website and YouTube channel, which now holds over 450 of our government contracting webinars. In the interest of time, we do not take questions. So if you do have questions for our speakers, we will have their information on a couple of the slides of the presentation today. Virginia PTAC at GMU offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you are interested in learning more, please use the links provided to explore what PTAC can offer. Set Aside Alert provides up-to-date news, information, and opportunities for small business federal contractors. Their daily opportunities alerts assure you won't miss important sources sought in solicitation announcements, providing details so you can jump on the hot ones. Every 2 weeks, they deliver concise breaking news, events, regulations, and teaming opportunities. And please join the Reston Chamber of Commerce Government Contractors Council for regular meetings. You can contact Alicia Fields with the email shown on your screen if you have any questions. Federal contracting is a relationship game. Now get in front of your federal human sooner with the exclusive Players and Layers method from Judy Bratt and Summit Insight. You can connect with her on LinkedIn and find out more, or visit growfedbiz.com today. If you're interested in selling to the federal government, you may need a contract vehicle. The most popular one is the GSA schedule. Learn more about the requirements, the proposal process, and how this contract vehicle may or may not be the right tool for you. Jennifer Schaus is teaching a couple classes, as you can see here, a part of a series, and all classes are listed on our website under the events section with the registration links. Okay, and now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance, and more information can be found on our website. We also have opportunities for your organization to advertise in our newsletter. We now reach over 23,000 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. And I also wanted to inform you of a new series that we're holding this year. We have launched a monthly series called the GovCon Q&A Cafe. And this is a live webinar series held each month, taking place on the second Friday of each month this year in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts on a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen, and then take your live questions about that topic. So for example, our panelists covered sales and capture this month, and then next month on July 9th, our panelists will be covering proposal writing. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab, and sponsorships are available. Please email hello@jenniferschaus.com for a media kit with pricing details. Also, please note that you can use code DFARS for a $15 discount on each of these webinars. Okay, and now to introduce our speakers. Frank Massaro and Sai Alba. Welcome. We're glad to have you here with us today, and I'll now turn the floor over to you.
Yeah, thank you very much. Yeah, this is Sai Alba. I'm a partner with the law firm of Polero Mazza in our government contracts group. I've been with Polero Mazza for about 15 years or so now. And we represent mainly small to mid-sized federal contractors, but we're expanding to a whole lot of other areas in with business and transactions, M&A, labor and employment, and litigation as well. In fact, I'm here with one of my colleagues in our business and transactions group, Frank Massaro, who will kind of help us go through some of these things, kind of take the lead here. So Frank, take it away.
Sure, thanks, Sai. Good afternoon, everyone. My name is Frank Massaro. As Sai mentioned, I work in the business and transactions group at Polero Mazza. Been there for about 2.5 years. Focus of my particular practice is advising businesses in mergers and acquisitions and other corporate matters. And I also work on a lot of data rights and software license issues for both commercial and government contracting clients. So, today's DFARS discussion on data rights will be right up our alley. So I think we can jump right in. Can we go to the next slide, please? All right, so today's discussion is on DFARS Part 227, which covers patents, data, and copyrights, which is, I would say, the wide gamut of potential intellectual property rights that the government might have with respect to something that is developed under a government contract. Now, the next slide, please. So as a quick overview of our presentation today, first we will discuss kind of the types of intellectual property that are potentially relevant to a government contract or that the government might receive some sort of rights in. And those include copyrights and patents, and then data rights, which is kind of an outgrowth of the DFARS and the FAR, and those really relate to the particular types of rights that the government can get into some sort of copywritten or patented material. Patents usually cover inventions and discoveries, things along those lines. Copyrights usually relate to some sort of work of authorship. So commonly books, music, and software, those would be copyright materials. And then there is a third category, another category of intellectual property, trademarks, which relates to names and logos and things like that. They're not addressed in the DFARS, so we won't discuss them today. And then the types of rights that the government can have in intellectual property, and these really relate to potential data rights that the government can get. Those are limited or restricted, government purpose, and unlimited. And then we'll also quickly touch on some little quirks related to commercial software licenses. Next slide, please.
Actually, the one thing to just generally go over before we get into the specifics is that when you're talking about patents or copyrights or anything like that, it's important to remember that really when you get a patent or you get a copyright or you have a common law copyright, all of those things don't really give you any more rights than you already had. What it does, it allows you to exclude others from participating in those rights or using things and commercializing things. Same thing applies vis-a-vis the federal government. So when you create something, and before we get into the specifics of all these different rules, the general rule or the baseline is that you own it and the government has some sort of license rights in it. And so when we're talking about what usually happens with this sort of default rule is that you never transfer ownership to the federal government. Again, this is generally, you don't transfer ownership to the federal government. And this is especially if you're a small business. If you're a small business, the government is never even supposed to try and take ownership from you. But you could transfer or allow the government, would be a better way to do it, to say it, allow the government to have some rights in whatever it is that you're looking at, your patents or your copyrights or your other intellectual property. And so I think that's just an important way to look at this, because sometimes people come at it the other way and say, well, if I register the copyright, I get something. Or if the government takes unlimited rights, I lose something. In a sense, that's true, and we'll get into that, but not really, because that's not talking about ownership. In all of these things, we're not talking about the transfer or granting of ownership rights. We're really talking about the granting of license rights in one form or another for the government to be allowed to do something that you, the contractor who developed this, already gets by the very nature of the fact that you were the one who did it, or even your employees. So I just think that's a starting point that I wanted to get us all in the right mindset.
That's a really good point, Cy. And I think we'll be kind of touching on that a lot throughout the discussion. And really, the contractor, whoever develops the intellectual property, owns it. And as Cy mentioned, the DFARS is really outlining what particular license rights, not ownership rights, but license rights the government might have in whatever your intellectual property is. So we'll start with patents. We can move on to the next slide, please. So a patent, as we talked about with invention, so it's a grant of a property right in an invention or discovery that is issued by the United States Patent and Trademark Office. And as I just mentioned, obtaining a patent doesn't really necessarily give you a right to do anything. If you've created an invention, assuming you aren't infringing on someone else's intellectual property rights, you already have the right to manufacture it, market it, sell it, and do all those fun things that you'd want to do with it. The benefit of obtaining the patent, if you can, is that you can exclude other people from doing all of those things. So if you have the patent, another company can't come along and manufacture and sell the thing that you just invented. And it also provides you with an opportunity to kind of enforce those rights and bring causes of action for any sort of infringement of the patent. So if someone does in fact try to sell something that is covered by your patent, you have established legal recourse against them to get them to stop. So the subject matter of a patent, it can't be anything that is just an idea or a suggestion. We need to have an actual invention, a process, some sort of manufacture, something that is described. And normally, the general patent is what we will call a utility patent. It's anything that is like a useful process or machine or article of manufacture. And it has to have some useful purpose and ability to perform that intended purpose. So it has to be more tangible than just an idea of something that would be helpful. Does that have anything to add?
I think just kind of going back to the issue we just addressed again, even if the government gets certain rights in your patent, which we're going through right now in a minute, that doesn't transfer rights to do whatever it is the government has rights to do based upon what's given to them to third parties directly. So even if the government does something or can provide sort of the specifications, let's say, of something that's patented to a third party to manufacture it for them, that does not give that third party the right to go take that and manufacture it outside or for some other purpose. They can only do it to the extent that the government grants them the license to do it for themselves. So people sometimes worry that, well, if the government gets the right to practice a patent, then that means it's worthless to me. That might be true vis-a-vis the federal government, but it's not true generally in the marketplace, the commercial marketplace. And that can be an important distinction depending on what your business is and where your customer base lies. So we'll get into that in a minute.
Sounds good. Thanks, Cy. Could we go to the next slide, please? All right, so as I was mentioning, the U.S. government can get some rights in patents. Usually, the federal government will add an applicable patent provision if the contract involves some sort of experimental, developmental, or research work. In other words, they don't just drop patent clauses in every single contract. So do you have any good examples of an experimental, developmental, or kind of research contract where we might see these kinds of provisions?
Yes, we saw a number of them come up recently in the past year dealing with COVID issues. whether it's testing equipment or new forms of PPE or things of that nature, where the government funded and is still funding that kind of activity. Now it's sort of been broadened. It's not just for COVID, but certain equipment could be used for like any viral or infective agent. And so the government is now looking at investing in those sorts of things, and they could do that through either contracts or SBIR, which is not directly related to what we're talking about today, but similar, the Small Business Innovation Research funding. So they can do it in that context where they're really creating something unique. And in addition to that, it can actually be a combination of something the government already created. Like for instance, if you're doing something space related, and it doesn't even have to be space related, there's a number of down to earth things that NASA controls as well, but you might be working with NASA, and NASA has a whole other program that allows them to actually license patents on things that NASA and NASA scientists have created over the years. And you could take something that NASA has a patent on and combine it with something else that you're working on and create a new product. In those sorts of cases, it's things called like the Space Act agreements or other things like that, where the government and you enter into something jointly. And when you do that, you create something new, but you might have joint ownership of that patent in some cases. And that's important. It's not just ownership all the time that we're talking about. You can have joint license rights or even joint ownership in a situation like that, where you both own it. You can both do whatever you want with it. Most of the time, though, you're in a situation where you create something like this new COVID testing scheme or this new PPE or something, and the government might have the right to manufacture or get some third party to do it for them, but then you still own it and you can bring it to the commercial marketplace. So that's kind of a good example. And another thing probably to note here is there are situations where even though something is patentable, you might not want to actually patent it, because I mentioned SBIR. I had a case dealing with SBIR, and it was mine rollers actually. And the company was given an SBIR contract to create a mine roller. As they were doing that, they patented it. However, when you have SBIR data rights, not the patent issue, but the data rights of all the other stuff that went into creating that could be copyrightable, those items are protected under the SBIR rules from disclosure. So the government cannot give that to third parties for 20 years. But once you patent it, anything that's in the patent, if you've given the government the right to practice the patent, anything that's now public in that patent application that the government has rights to, they can share that with third parties for their own uses. So in that particular context, by patenting something and thinking that's like the pinnacle of protection that you can get, that's true vis-a-vis third parties and the commercial marketplace. But in this particular context, if you have competing potential rights between SBIR in this case and patent, you might not want to patent if your only customer is the federal government. Because if your customer is the federal government, by getting a patent and allowing them to practice that patent, you've allowed them to get a third party to come and manufacture something for you. This new experimental thing you created, now the government can go to someone else and get them to actually make it for them, not you. Whereas had you just stuck with the SBIR rights, they wouldn't have been able to disclose to third parties the sort of secret sauce that's covered by the SBIR clauses. So depending on what you're doing, you want to kind of think through all the angles before you make the business determination as to whether or not to patent something.
And that's a really good point, Simon. That really ties into this idea that, which we'll stress throughout, is that, to the extent something is invented or developed during the course of the contract, the contractor will own that intellectual property, whether or not it's patentable or you obtain the patent. And the government's going to get that license, and we'll talk about kind of what that license would permit them to do. And we'll also mention throughout the concept of a subject invention, and that's just the FARS way, or the DFARS way, of identifying an invention that was developed under the course of the contract, because certainly, the government's not necessarily asserting any sort of intellectual property type rights in anything that was developed outside of the contract. Next slide, please. So as the default, the contractor may elect to retain ownership of the subject invention, provided that it complies with the DFARS and asserts its rights in certain ways. So the easy thing is, if you don't want it, the contractor does not want to retain ownership, it can simply elect not to retain ownership, and then the government will obtain some ownership rights in the invention. But for the contractor to appropriately assert its rights, it must do a few things. First, it has to disclose the invention or the discovery in writing to the contracting officer, either within 2 months after it was disclosed to the contractor's personnel who's responsible for patent matters, or within 6 months of when the contractor first becomes aware that a subject invention was made. And this disclosure should include the contract under which the intellectual property was developed, who invented it, sufficient technical detail to really provide an understanding of what the invention or discovery is. And then to the extent there's been any sort of publications or manuscripts written or made about this invention, those are also disclosed to the CO. And then the contractor needs to elect whether it will retain its ownership, and if it wants to assert any patent ownership claims, at least with respect to the US government in a foreign country, it needs to identify those countries. And then it must file appropriate patent applications within certain periods of time. So that either involves a provisional or non-provisional application within 1 year of election. If it does file a provisional application, then it needs to follow up with a subsequent non-provisional application within certain periods. And then to the extent we have elected, or the contractor has elected, to assert patent rights in any sort of foreign country, it needs to take steps to file applications asserting the patent rights in those countries. So provided that the contractor has followed these steps and appropriately asserted its rights, it will obtain ownership to the subject invention under the DFARS. However, the government will still obtain some sort of license rights to the subject invention. So those license rights will be non-exclusive, so the contractor can provide other license rights to other entities. It's not transferable, so the government can't transfer it to anyone. It is irrevocable, so the contractor can never take it away from the government, and it is paid up. So the government will not owe any future royalties to the contractor with respect to the license or the subject invention. And it can also assign its rights to others for government purposes. And as I was mentioning earlier, that could mean that competitors might be assigned some rights and therefore might have some ability to manufacture whatever the subject invention is for the government. The government also has what are called march-in rights, and these are very limited rights wherein the government can march in and then require the contractor to license the subject invention in certain circumstances. These are very limited circumstances. They can arise if the government believes that something is necessary to alleviate health or safety needs or to meet requirements for public use. And also if it believes that the contractor is not taking reasonable steps to achieve practical application of the subject invention. And that basically means that, the contractor is working to utilize a patent and more or less make its benefits available to the public for a reasonable price. In other words, it's just not sitting on the patent and doing nothing with it. Now, Sai, you had mentioned some PPE and other COVID-related matters on the last slide. I was just curious if you had seen any march-in rights, for example, with respect to any of those matters in the past few months, for something that might be necessary for public use or health or safety needs or anything like that.
What's actually funny is a lot of people, like the public, I'll just say the public, I saw articles pushing Biden to use march-in rights in order to, and maybe Trump, it was happening recently though, because I think it was giving vaccines and stuff to third parties, other countries, to use the march-in rights that the government has. It actually doesn't just apply to the DFARS or when the government pays for something, because the only reason you have a patent is because the U.S. federal government allowed you to have a patent. Sounds kind of un-American, but at the end of the day, our whole system harkens back to like a monarchical view of things. And so the U.S. federal government is seen as the sovereign in a whole bunch of legal provisions, including here. And so as the sovereign, the federal government is the one who gives you the right to have a patent and the right to exclude others from using something. And as part of their inherent rights as the sovereign, they can come in and say, hey, that patent we allowed you to have, we are now taking it away. And we are saying for this particular purpose, I'm the government and I'm coming in and saying, I want that right back and I'm going to give it to someone else. It has never been used that I'm aware of. There came up in COVID. There was also some sort of rare illness, and this kind of brings it home. There was a rare illness a number of years ago, and I can't remember what it was, but it afflicted children. And the government thought about using its march-in rights to force companies to use their manufacturing and push it out, or take the IP and allow other companies to manufacture it, so that it would grow the amount of this medicine that was in the public. And the US government decided not to. Simultaneously, the European government decided to do it, or threatened to do it. And what's crazy is the US manufacturer then agreed to manufacture more of this medicine and to ship it all to Europe. So the US children could not benefit from the US manufacture of a US medicine. And instead it went to European countries because they were threatening to use this against the company if they didn't do it. And the US really didn't make that threat. And so that's sort of an example of this sort of thing happens all the time, and the government is really reluctant to use this. So I actually did an article a while ago on this, calling it the paper Damoclean sword, because it exists out there, but does it really if you're never going to use it, even in sort of extreme circumstances? So I wouldn't be too worried about this, although it's good to know that in theory it exists.
And it's also good to, as you mentioned, Sai, that this isn't DFARS specific. This is in the this is statutory. This applies to all patents, the march-in rights. So, okay, can we go to the next slide, please? Okay, so as we mentioned, the default rule is the contractor will own the patent, provided that it follows the appropriate steps under the DFARS to assert its ownership. So the upshot is that if you don't do those things, then the government can obtain a title to the subject invention. So, the easy thing is, if the contractor elects not to retain title, then the government will obtain title. Alternatively, if the contractor does not make timely disclosure of the subject invention, or does not timely file the appropriate patent applications, then the government can't obtain title. Now, even if the government does obtain title, unless the contractor fails to make certain disclosures of the subject invention, contractor will still obtain a non-exclusive royalty-free license to practice the subject invention. This does give the contractor some ability to grant sublicenses to the extent that it must do so under the contract. Can also transfer the license, but usually requires the agency's approval to do so. And then in limited circumstances, the government may revoke the license. Again, this usually comes back to our issue of practical application. If the government's granted you the patent license, then they want to make sure that you're trying to use it, and if you're not, then they might revoke it. Sai, do you have anything else to add?
Yeah, I've seen this thing come up in certain cases, or shipbuilding matter, where the client had developed something themselves, but then it sort of got intermingled with this special way they created of, I think it was an add-on or something to CAD, and it was pretty complicated, and it allowed them to sort of design the ship and manufacture things with much more precision. And because of COVID issues, they weren't able to do it for the full number of ships the government needed. And so they wanted to give it to a third party to manufacture some of these other ships. But they wanted to take advantage of this sort of proprietary software, or this proprietary, it was part software, part actually like the machine that they used to create some of these plans. And so the government did try to assert other rights, because the development of this had gone on for years under other contracts the government had paid for. And they started really wanting to know the nitty gritty of how this device, so it was both data rights and patent rights, how this sort of device was created, and whether or not they should have had other rights, and whether or not the company did the right thing, years ago when this was first developed. So it can get pretty complicated, and it's always easier to deal with in the moment. So make sure you're following these things pretty carefully at the outset. You don't want to have to deal with it 4 years down the road or 5 years down the road.
That's a very good point, Sai. If we go to the next slide, you can actually see some additional, obligations that the contractor has, to protect its interest and the government's interest. So this is under the DFARS. This is not an exhaustive list. The DFARS expects that the contractor will require, for example, its employees to disclose subject inventions, that you're notifying the contracting officer of your decisions regarding the filing of the patent applications. Any sort of, you avoid certain royalties for licenses with respect to government funding. You're furnishing certain reports regarding your subject inventions. So I don't think we need to spend a lot of time on these. Just be aware that there are other things that you will need to do on an ongoing basis, just to ensure that you're appropriately complying with the DFARS to assert and retain your patent rights. So I think this is the last patent slide. Do you have anything else you want to add before we move over to copyrights?
The only thing, and neither Frank nor I are patent lawyers, just so everyone's aware, there's like a special patent bar people have to be a part of. But I will say that when you are if you're looking to get a patent on something, and you think you might be able to get it, that there is a first to file rule now. So if there's a competing company that's doing something similar, or in this one case I had, the government was actually funding multiple research avenues on the same thing. And, I assume there were little differences, but it was very minor. And in fact, what happened was a third party filed some patent on an item that looked very similar to what our client was trying to create. And they thought the government had improperly given information away. And what actually was happening, as I sort of was alluding to, is that the government was actually funding 2 of these, and they were the first to file. And it was something where the differences, what the patent lawyer told him, is the differences between what we were creating and thinking about patenting and what the other company had patented were not sufficient to warrant a second patent. And so by the other company sort of getting there first, this other company, now they didn't spend a ton of their own resources because a lot of it was government funding, but they thought that they were creating something that they would then own and be able to potentially sell around the world to other governments and other third parties. And because of this first to file rule, they lost that opportunity. And so that's just something to make note of, that obviously you need to be far enough along when you're filing a patent so that it would stand up, right? And the patent office would actually give you the patent. But at the same time, you don't want to sit around and make sure everything's perfect, or wait till you have an actual working prototype or something, right, before you're patenting something. You need to try to make sure you're patenting it earlier on in the process, and make sure you're working with the appropriate sort of advisors or patent lawyers to check and make sure there's nothing else out there.
Sounds good. Thank you, Sai. Can we move on to the next slide? All right, so next we'll talk about copyrights. We can move on to the next slide too, please. So this will be a pretty quick discussion because a lot of this flows into data rights, which is really the concern that the DFARS is addressing and really what the government will get So as we mentioned initially, copyright is intellectual property that relates to original works of authorship, so books, music, software. Unlike a patent, you don't need to necessarily file for a copyright to obtain your intellectual property rights or to assert them. Now, it certainly helps because now there's a public record that you are asserting copyright, intellectual property rights in software or the book or whatever it is you've created. But a copyright is secured automatically whenever the work is first created. So once the company creates a software program, then it has copyright rights in that software program. But as I mentioned, the registration is helpful in kind of putting people on notice and helping to assert your rights. And as I mentioned at the outset, getting the copyright doesn't necessarily let you do anything more than you already could have done. If you create the software, whether or not you file for a copyright, you can still develop and sell and license the software. But asserting the copyright prevents other people from selling or developing the same software. Can we go on the next slide, please? And as we mentioned, again, software is copyrightable material, and having the copyright rights permits you to reproduce it, prepare derivative and other works, distribute it, or sell it, and display it, do all those kinds of things that an owner could do while simultaneously excluding any other company from again creating a derivative work or otherwise kind of infringing on those rights. And to the extent some software is developed or some other copyright is developed under a government contract, again, the default is that the contractor will own the copyright and the intellectual property, but that the government will obtain some data rights in the technical data or the computer software. And that's the next thing we'll discuss. Can we move on to the next slide? Sai, actually, do you have anything to add regarding copyrights?
I mean, the only thing I think is that to the point on the first slide about it has to be something unique and sort of artistic, right, or whatever. You can't just copyright everything. I know people put copyright on everything. I think we even do things on certain forms or things that you've created that you think are great, right? Well, the general law doesn't really protect things that they consider to be not creative. So even if you have some subcontract that you think is amazing and you wrote this clause, it's like the perfect clause and covers everything, that's not the kind of thing that can be copyrighted. And I've seen clients who have created things like manuals or training things for people. And unless there's something pretty unique there, I mean, you could put copyright on it, but if somebody were to take something and reuse it and you tried to sue, it can be an uphill battle. So just sort of realize, but a lot of times just marking things might be sufficient, so you could try that, of course.
That is good advice. Okay, so can we move on to the next slide? Actually, skip this slide. Data rights. That's the next. That's the next topic that we'll go over. So, what are data rights? So, data rights are the non-exclusive license rights in technical data or computer software that is delivered by contractors under a DoD contract. So, we'll discuss these more in detail. And again, the default is that the contractor owns the data rights in these things, or owns the intellectual property, and that the government is only getting some license to those rights. And in determining kind of what are the government's data rights and how far do they extend, kind of depends on, in large part, on when it was developed, how it was developed, and then who paid for the development. Go to the next slide, please. So then, what does it mean to be developed? So under the DFARS, the development requires that an item, component, or process is workable. Workable means that reasonable people skilled in the applicable art conclude that there is a high probability, that the item or process will work as intended. That does not mean that it is perfect and bug-free, that does not mean that it will accomplish everything it sets out to, or that it is ready to be sold in the commercial market. There can still be some bug fixes that are necessary or tweaks, but as long as if there's a high probability that it will work as intended, we are concerned that we are satisfied that it is developed. And you'll also notice that the definition relates to items, components, and processes. It does not say software or technical data. So the concept of development kind of looks at the lowest possible level and determines whether those pieces of a greater whole are quote unquote developed. So the issue isn't necessarily whether the software or the end product that combines all of these components is workable, but whether each component is, or whether a particular component is. And as a result, it's possible that the government can obtain different types of license rights or data rights in different components of one piece of software.
Yeah, and that's where you want to be careful, because if you're developing something and you're doing it and you're just taking all this time to develop this holistic thing that does 30 different things, instead of doing it in a way that it can't ever be, like, let's say software can never be compiled and be run, so there's no executable until you have all 30 things done, is not a good strategy if you're working for the federal government. Because if you start to do something and create something and then it's still not compilable, it doesn't actually do what you intended it to do, and no component at the lowest level is operable, then the government starts giving you a bunch of funding and then the whole thing becomes operable. The government can likely argue for unlimited rights in the entire thing, or at the very least government purpose rights, which we'll get into. Whereas if you had developed that early stage at private expense and created little subcomponents or modules that all attach to each other, and maybe there's some underlying piece that can run independent of the modules, if you did it that way, you could restrict the government's rights more than if you did it the way I discussed at the beginning. So be aware of that when you're creating, especially software and things like that.
And that's a great segue, Sai. Can we go to the next slide? Sai mentioned kind of where is that funding coming from, whether it's the government funding or your own private expenses, but that's a huge component of what kind of data rights the government will get. So the easy ones are those that are exclusively funded at private expense. That means the development was accomplished either with no government money at all, or, for example, with costs charged to indirect cost pools. Again, we make these determinations at the lowest possible level of development. Alternatively, if the government funds are exclusively used to develop this, then it's obviously developed exclusively with the government funds. Of course, there's a middle ground. If some component was partially funded with mixed funding and partially funded at private expense, we'll give the government some, I guess, middle ground rights, which we'll talk about in a minute. But an important clarification here is that this concept of mixed funding and the government purpose rights that we'll talk about that kind of arise from it, this is only a DFARS concept. This does not appear in the FARS or the FAR. So, if government funding is used in whole or in part for development, then under the FAR, if you're dealing with non-DoD agencies, it will be treated as though it was, I guess, exclusively funded with government funds, and the government will be in a position to assert those highest possible rights with respect to that component. Okay, do you want to move to the next slide? Okay, so the main applicable DFARS clauses that we'll talk about are 227.71 and 227.72, and they're applicable contract clauses 7013 and 7014. But we'll see on the next slide that there are other provisions that can come into play, which might be, can we go to the next slide, please? Yeah, thank you. Other provisions that might come into play and be included into solicitations or contracts, depending on whether we're dealing with technical data, whether it's computer software, commercial or non-commercial. So do you think there's anything specific you'd want to, any particular provision that warrants additional discussion at this stage other than 13 and 14?
No, those are the main things.
Okay, so this helpful just to be aware that these might be included in a solicitation and they might have some additional obligations or impact on the contract or solicitation. So we go to the next slide. We had mentioned technical data, computer software. So these are the main categories of information and material that the government can obtain data rights in. So technical data is recorded information of scientific or technical nature. It excludes software and other incidental data to contract administration. Computer software or your computer programs, your source code, your listings or object code, and all these other things. It does not include computer database or computer software documentation. And just for additional information, the computer database is the collection of recorded data in a form capable of being processed by a computer. Also excludes computer software. And then the documentation are the manuals, the installation instructions, and similar documentation that kind of explain the capabilities of the software or provide instructions on using it. So we go to the next slide, please. Another point that's relevant here is whether we're dealing with commercial or non-commercial computer software. DFARS 252, 227, 7014 kind of relates to this concept of commercial computer software, and it explains that a commercial computer software means software that was developed or regularly used for non-governmental purposes, which has been sold or offered for sale, lease, or licensed to the public. If it hasn't been, it will be available for sale when it's delivered under the contract, or it satisfies one of those two, and we're only making some minor modification to meet the requirements of the contract. So, this does not necessarily mean that the product is sold commercially, just that, it more or less could be. DFARS is also very helpful to say that non-commercial software is basically anything else. So if it doesn't qualify under one of these requirements to be commercial software, it is then non-commercial software under the DFARS. So anything you'd like to add in this distinction before we start diving into license rights?
No, I think, well, the only thing would be, I guess, commercial software. If you can make something commercial software, if there's an argument that it's commercial, you want to do that, because then you can create the license agreement and not have to worry about any legends or other stuff, which we'll get into in a second. And I'll explain why as we go through it.
Yeah, that's a good point. If we can say it's commercial, we should try. and we'll see the distinction shortly. So we go to the next slide, please. All right, so now we're going to talk about what those particular license rights the government may get could be. Go to the next slide, please. Okay, so again, the general rule is the contractor is going to retain title and ownership in whatever the underlying software or technical data is, but the government is going to maintain some license. And this applies whether we're dealing with technical data or commercial software. Go to the next slide, please. So these license rights under the DFARS can come in the form of limited rights, restricted rights, unlimited rights, or government purpose rights. There are also inchoate rights that I guess don't really come up very much, if at all, under the DFARS. So we're not really going to touch on those. So we go to the next slide. So the first group of rights are limited rights. So and this applies to technical data, not computer software, that was developed exclusively at private expense. If that's the case, the government only has the license to use, modify, reproduce this technical data within the government. It cannot release or disclose it outside of the government, except in very narrow circumstances. Some of these might come up if a narrow circumstance might be if it's necessary for emergency repair or overhaul, or if it's necessary to disclose to certain covered government support contractors to perform their contracts. This is, I guess, the best level of rights that, or the most limited rights that the government can get to technical data. So the best for the contractor. Keep in mind that this is the default, and that if the government wants additional rights, certainly up to negotiation, the contractor is certainly free to grant additional rights pursuant to a license agreement. The next slide. Very similar to limited rights are restricted rights. These, on the other hand, apply to non-commercial computer software, rather than technical data that has been developed at private expense. So, this lets the government use a computer program with one computer at a time, transfer it to another government agency, provided it destroys all the copies, make a minimum number of copies solely for safekeeping and backup, maybe modify the software for limited purposes, and also permit some contractors and subcontractors to use for limited purposes. Again, this is the lowest form of, or the most limited rights that the government can get in non-commercial computer software. So it's the best position to be in for the contractor. And similar to limited rights, this is the default. Certainly, if the government wants additional rights, they're subject to negotiation with the contractor pursuant to a license agreement. So
yeah, and that was if everything was developed at private expense, then this is sort of what you can do. But you have to make sure if it's, again, this is non-commercial. All these things we're talking about is non-commercial software, non-commercial technical data. If you're looking at this stuff, you need to make sure if you're going to restrict rights that you include the exact legend verbatim from the DFARS clause, the appropriate clause, on, if it's a piece of software, we recommend putting it on the physical medium, and also in like a EULA or splash screen or something like that that pops up. And then if you really want to take it to the next level, if you have subcomponents like we talked about before inside the uncompiled code, you can put sort of brackets around things and say, this portion of the code was developed at private expense, therefore it's restricted rights. This portion of the code you paid for, you get unlimited rights. This portion is mixed government purpose rights, which we'll get into in a second. But you need to make sure you put that exact legend in there. Just saying this is copyrighted, shall not be disclosed, or something generic like that is not sufficient to protect your rights in non-commercial data and non-commercial computer software. You need the exact legend, and that gets screwed up a lot. And then again, 5 years, 10 years down the road, people think they can restrict the government's rights, and they say, no, we got this a decade ago or 20 years ago, and you didn't restrict our rights, so it's ours. Not ours. I shouldn't say that. They have unlimited rights in it. So that would happen if you screw up. They take unlimited rights.
That's a very good point, Sai, and it bears repeating. It's important that to the extent you can assert rights, you should make it very clear to the government or any subcontractor or third party that you are asserting these, you are asserting those rights, and that you've already, for example, developed this entire component or software program at private expense to hopefully put the government on notice on the front end about what you think or what the contractor believes they're only granting limited, restricted, or otherwise rights in. So then the next category, go to the next slide, are what are called government purpose rights. This applies to both non-commercial technical data and computer software, but this arises when we're developed with mixed funding. Kind of, as we mentioned earlier, this is a DFARS thing. It's not a FAR concept. So if something is developed under a civilian / non-DoD contract, government purpose rights don't exist. They don't apply. So to the extent the government has government purpose rights, this allows them to use the data or the commercial software, the computer software internally and externally for government purposes. There's any activity in which the government is a party. The good thing is government purpose does not include commercial purposes. So the government can't use, modify, or reproduce the computer software or the technical data for commercial purposes, and it is unable to authorize any third parties to do so. So even if the government could provide some license to another contractor to manufacture something for the government's use, it can't permit that government contractor, that third party, to manufacture for a commercial use or for a commercial customer. The government purpose rights are only last for a certain period of time, and then they convert to unlimited rights after that period. Now, the default under the contract clause is 5 years, but it is subject to negotiation among the parties. And that period either commences beginning upon the execution of the contract, or if there is an options exercise that requires this development or kind of triggers the development, that would be subject to government purpose rights on the execution of that option. Sai, anything you'd like to add about government purpose rights?
And then we just the SBIR rules used to mirror this, but they don't anymore. Instead of SBIR rights being for 5 years and then going unrestricted, it's now 20 years and then it goes government purpose. So that was a pretty huge change.
All right. Can we have the next slide, please? So unlimited rights. This is the last, I guess, category of data rights the government can receive or obtain. It again applies both to technical data and software, but this is for those developed exclusively with government funds, including under a government contract. Basically, the government can do whatever it wants with the data or the software. Now, keep in mind that as a default rule, the contractor still retains ownership of the technical data or the computer software. So the government's rights, while unlimited, are not exclusive. So the contractor still has the ability to sublicense to other third parties if it so desires. Also keep in mind that the government's going to obtain rights, unlimited rights, in what is called form, fit, and function data. And that's kind of information that describes the physical, functional, and performance characteristics of the item, component, or process. Other information that's needed for installation, operation, maintenance, and training. And then, any data that's been furnished under government purpose rights or unlimited rights or restricted rights that have expired. So, as we mentioned, that the government purpose rights have a default 5-year period that's subject to negotiation. At the end of that period, the government's rights turn into unlimited rights.
And if the government has unlimited rights in a particular thing, like say a piece of software, you cannot charge the government a license fee for that software. But remember, the unlimited rights they get is in the exact item, the exact software that they paid to develop. And so if you develop other components to it, and this is kind of the trick to all of this, if you develop new components at private expense to layer on top of this, assuming you didn't accidentally give away ownership, which you should never do, and they're never supposed to ask for it. But if you just gave them unlimited rights and then you have new components that were developed purely at private expense, and you go back and sell to the other government agencies or back to the same agency, this new development and this new component that's amazing, and they're like, oh yeah, I really want that. You can charge whatever you want for that component and say, well, yeah, no, you have this like base level software that I can't charge you license fees for. But if you want this magical new piece of it, that's gonna cost you $10,000 a user per month or whatever, right? And so that's kind of the trick, using what we already talked about. If you've developed it at private expense, and then especially if you make it commercial, you give them a license agreement, which we'll talk about in 1 second. That's how you kind of make the hook.
That's a good point, Sai. And perhaps I glossed over this a little bit going through, but as we mentioned at the beginning, like the data rights are focused on the lowest possible component at the lowest level. So it's possible that some component was made exclusive with government funds, so unlimited rights, whereas others might have been created or developed at private expense, so limited or restricted rights. So it kind of all works together, and the unlimited rights won't necessarily apply to the whole software if parts components were not developed with government funding. Go to the next slide. And finally, we'll quickly touch on commercial software licenses. Most of the previous discussion about computer software and technical data related to non-commercial versions of that information. Under the DFARS, there's an expectation that the government would acquire any commercial computer software under the license that are customarily provided to the public. So if there's already a EULA in place or that is generally offered when someone buys the software, that's what the government expects to obtain. Now, many software licenses include provisions that conflict with procurement law that the CO can't agree to. So to the extent there are these inconsistencies, for example, sometimes the licensor can terminate the license unilaterally. That's not permissible. So unless they're, to the extent a term of the commercial software license conflicts with federal law, it's not going to be not enforceable against the government. Next slide, please. So that is all. That is the extent of our presentation regarding data rights, patents, and copyrights under the FAR. Please let us know. Feel free to reach out to Sai or me if you have any questions or like any assistance. We are happy to help.
Yeah, and thank you so much to both Sai and Frank for a great presentation and sharing your time with us today. And thank you to everyone who joined us for this webinar. Please reach out to them with any questions you may have. And then the recording of this webinar will be on our website and YouTube channel within the next 24 hours. And please join us next week as we cover more parts of the DFARS.